So welcome to Jumbo IS and welcome to lecture number 10 of this lecture series called Prelims Powerplay 2026. Now today is the last lecture of Polity in phase 1. Okay, as you all know, if you are familiar with the timetable of Prelims Powerplay, well, we will cover the entire syllabus for revision for Prelims in 3 phases, right? So Polity in phase 1 would get over with today's lecture. By the way, if you're not familiar with the timetable of this lecture series, which will revise your entire syllabus, well, go to our app or our website and download the timetable for this lecture series. Okay. Now, today is the last lecture, lecture number 10 of Polity. And that means that tomorrow you will have a test. Okay. The syllabus of the test would be whatever we have covered so far in the past 10 days for Polity. Okay. So, the test would be conducted tomorrow at 9 p.m. Okay. In your app and your website, whichever way you are accessing the course, okay, you have tomorrow's entire day to revise whatever you have covered so far. You have tomorrow's entire day. So do that revision. It is very important, okay? And then give the test at 9 p.m. It will be a 1-hour test, 50 MCQs, and will comprehensively cover all your syllabus of whatever was covered in the past 10 days. Okay, all right. So today's lecture is titled Criminal Justice System, and there is a good reason behind this. Why? Well, the thing is that whenever students or aspirants prepare for Polity, for UPSC, they always refer to this book called Lakshmikant. Now, Lakshmikant mostly deals with constitution portion of our Polity, okay? It deals with constitution, some important laws, and that's about it, right? But in recent times, UPSC has started asking questions not related to constitution, but can be very well be said to be a part of Polity syllabus. Okay, they are technically part of Polity, but not related to constitution and are not found in Lakshmikant. So UPSC has started asking questions which are outside Lakshmikant. One such topic that is, well, not mentioned properly in Lakshmikant book is criminal justice system. And this criminal justice system is very important because in the past 1 year, government has conducted so many reforms. It was a hot topic in current affairs. Government has conducted so many reforms to basically improve our criminal justice system. Clear? So today we will focus on criminal justice system. Okay, criminal laws in our country, the problems it faces, and well, the reforms that the government has undertaken to improve this system. Okay, so let's start with criminal justice system. Okay, Polity lecture 10, criminal justice system. Now, what is basically criminal justice system? Well, in our country, there are laws. And most of these laws are called criminal laws. Okay. Now, if you break these laws, there is a proper system as to how the state would act against you if you break these laws. Clear? So, criminal justice system deals with this entire state machinery that takes care of criminal legal system in India. Okay, this entire state machinery is known as criminal justice system. Okay, now let's talk about criminal justice system a bit more and then we'll get to the reforms part. Okay, so criminal justice system in India has 3 components. Clear? Number 1 component is the police. Police makes sure that all the criminal laws in India are adhered to, and whoever breaks these laws, well, the police would catch that culprit. Okay. So police is component number 1 of criminal justice system. The first point of contact, responsible for receiving complaints, FIRs, investigating crimes, collecting evidence and apprehending suspects. Clear? Then the second portion is judiciary. They hear cases against these culprits. Okay? Adjudicate cases, hear arguments from both the prosecution and defense and deliver judgments based on the evidence. And then if you are convicted of a criminal offense, then the third component of criminal justice system comes in, and that is the prison system. Also known as, remember this name, correctional facilities or correctional administration, which includes prison services, probation services, responsible for punishing and rehabilitating offenders. So these are the 3 components of criminal justice system. Always remember this. Clear? Now, what is this entire process that goes about when someone breaks a law? How does this criminal justice system operate? So there are various steps. There is a proper procedure that is followed in India when this criminal justice system operates. Basically, there is a proper procedure. Okay. So let's talk about some steps of this procedure. Okay. So the usual process is whenever there is a complaint against a person who has broken a law, you go to a police station and the police files first information report. Okay, FIR. This is step number 1. After the filing of this complaint, FIR, then the police investigates the matter. Police investigates the case and gathers evidence. Clear? Once the police gathers evidence, okay, investigates, then the police catches the culprit. And then when the arrest happens, police goes to the magistrate to take that person's remand. Third step is arrest and remand. Arrested person must be produced before a magistrate within 24 hours. This is mandatory, okay? Further detention, if the police wants to keep this suspect for more time, they have to take the permission of the magistrate. Then, after catching that arrested person, the police investigates further, gathers evidence, and then files a charge sheet in the court. Charge sheet is basically, well, whatever facts the police has with respect to the case, that is a charge sheet. So if sufficient evidence is found, the police files a charge sheet with the court. Then, trial takes place in the court. Okay? Now the thing is, whenever there is a criminal who has broken some law, well, he has acted against the state. Because by breaking that law, he has, well, acted against the state machinery. Okay? So he has acted against state. So state will fight that case against that criminal. Okay? So it is generally state versus the criminal, the case that goes on. Now the state is represented by public prosecutor, and the criminal is represented by a defense lawyer. Remember this terminology. The lawyer for the state is public prosecutor, and the lawyer for the criminal or the accused is defense lawyer. And finally, the court delivers a judgment. The court delivers the final judgment, either acquitting the person if no evidence is found, or convicting the person. Make sense? Now remember this. This entire criminal justice system, okay, we just discussed this, that this entire criminal justice system consists of 3 components, right? The police, the judiciary, and the prison system. Okay, the main job of police is to enforce criminal laws. The job of judiciary is to hear cases. The job of prisons is to take care of or rehabilitate these persons, okay, who are convicted of a crime. Now, when we talk about reforms in our criminal justice system, we talk about legal reforms, judicial reforms, and prison reforms, because all 3 components face various problems. Okay, so we will talk about these reforms one by one. First, let's talk about criminal law reforms. Clear? Now, criminal laws in our country were of 3 types. You need to remember this. Then we'll talk about reforms. Criminal laws in our country were of 3 types. One was the Indian Penal Code, which listed down all the offences that a criminal can commit. Okay, it was created in 1860 during British times. Then the Criminal Procedure Code, 1973. It basically lists down what would be the process of punishing that criminal, catching him, arresting him or her, punishing him, the entire process, how the case would be fought in court, all the rules and regulations with respect to the entire procedure in criminal cases is Criminal Procedure Code, and how the evidence would be collected, presented in the court, filed in the court is mentioned in Indian Evidence Act, 1872. Which evidence is admissible in court, which is not admissible in court, it is found in Indian Evidence Act. Now, as you can see, these 3 criminal laws, okay, most of them except Criminal Procedure Code are British era laws. Okay, times have changed now. India has changed now. Therefore, this reform was long pending, that we overhaul this entire criminal legal system. And the government did just that in 2023. These 3 criminal laws were replaced with 3 new laws. Okay, so what were these 3 new laws? Remember them. Number 1, for Indian Penal Code, there was Bharatiya Nyaya Sanhita. For Criminal Procedure Code, there is Bharatiya Nagarik Suraksha Sanhita. And for Indian Evidence Act, there is Bharatiya Sakshay Adhiniyam. Now, what was the purpose behind overhauling these 3 laws, completely replacing them with these new laws? Okay, what was the purpose behind this move? This big reform, criminal law reform. Okay, decolonization. Number 1 was decolonization. The reforms represent a major effort to shed the colonial era framework for previous laws. Then, these are colonial era laws. Okay, Back in 1860, there was no such thing as cyber crime. And many new crimes have come out now. Cryptocurrency fraud, right? So, well, we can't rely on colonial era laws to fight against modern crimes, right? So we had to modernize the system as well. So the changes address modern issues like cybercrime and digital evidence, okay? And then citizen-centric approach. The new provisions aim to make the justice system more responsive, accessible, and for the betterment of the citizens. So these were the three major objectives for bringing in these three new laws. Make sense? Okay. So this is the first step, criminal law reforms. Now, what important changes were made through these three laws? Let's talk about that. Okay. So important changes. First of all, new offenses, modern offenses were added. The law criminalizes mob lynching, introduces specific penalties for organized crime and terrorism. Okay. Plus introduces a new chapter on crimes against women and children. Okay. Then next thing is very nice, very good, because you must have seen this in Western countries. Okay. For minor crimes, the judge doesn't order. You must have seen this in Western TV shows also. The judge doesn't order a jail term for minor petty crimes. He orders community service. Okay. Now, there was no such provision for community service in India. This was added in this new law. Okay. So, community service can now be a punishment for petty offenses. Clear? Then procedural modernization. New laws enable zero FIRs, online registration of police complaints, electronic summons. Okay. Not just paper summons by post. Mandatory videography. Yes, under these new laws, when the police conducts a raid or search warrant is issued, when the police conducts a search or seizure of a particular place, they have to do videography also. This is done. Justice timeline was introduced. New laws mandate that judgments are expected within 45 days of the trial's conclusion, and that charges must be framed within 60 days. You know, our legal system has this one flaw, and that is, well, time. Some cases take so many years. That had to be reduced through this. Okay. And last is terrorism and state security. BNS includes new provisions for organized crimes like drug trafficking, human trafficking, and terrorism. Clear? So these important changes were brought in our criminal legal system through these three new laws. Remember this, okay? And also remember which law replaces which one. Make sense? Okay. Now let's talk about, so we did police or criminal reforms in criminal law. Now let's talk about judicial reforms, okay? So what should be done in judicial reforms, okay? You all know that the biggest problem in our judiciary is pendency of cases, right? Pendency of cases, lack of enough judges, lack of infrastructure, some transparency issues are also there. So there are so many problems. We all are aware of our judicial system. So to reform all of that, certain steps were taken, okay? So in judiciary, well, tech reforms were taken, e-courts project, which makes the entire court proceedings paperless for more efficiency. Then National Automated Fingerprint Identification System, NAFIS, to identify criminals quickly through their fingerprint, okay? Compulsory videography, we just talked about that, okay? Then increase in the number of judges to help manage the backlog of pending cases. Then improve judicial infrastructure. Then for certain crimes like crimes against women, crimes against children, fast track courts have been set up, special courts have been set up. Because in existing court infrastructure, well, these cases take a lot of time. There are so many pending cases. So you have created special fast track courts which will deliver justice quickly. So these are some of the reforms in judiciary. Okay, but now let's come to the main point. The reason why I included criminal justice system as a topic in today's lecture, okay? And that is prison reforms. So many articles were published in the Indian Express or the Hindu with respect to prison reforms. You know, our prisons suffer from various problems. What are those problems? Well, overcrowding. Okay, most prisons in India have, well, more than or are operating at more than 100% of their capacity. That means they can house only 100 prisoners, but they have filled in 200 prisoners. Okay, overcrowding is there. And whenever there is overcrowding, prison management becomes difficult. Okay, plus facilities are also stretched. Prisoners do not receive adequate facilities. That is a problem. Plus, do you know why overcrowding is there? The biggest reason of overcrowding is under trials. Now, who are under trials? Most of you know about this, okay? But let me explain under trials, or explain this concept of under trials to those who do not know about it, okay? The thing is that there is this maxim called innocent until proven guilty. Let's suppose there is an accused, okay? Now, that accused is fighting a case in the court. The court is listening to that case, hearing that case, okay? So far, the court has not delivered a judgment. But because this accused is extremely poor and cannot afford a good lawyer, or the crime that this person committed was so heinous that the police asked the magistrate to keep him in their custody. Okay, the police asked the magistrate that we cannot allow this person to go free until the case's verdict is delivered. Okay, so we will detain him in our jails. Clear? Now, this person has not been proven guilty so far. The case is currently going on in the court, but because of lack of good legal services, okay, good lawyer, or the nature of the crime, the police somehow found a way out to detain that person in the jail. That person might be innocent, but he will be in jail. That person is called under trial. So under trials are partially guilty. Why am I calling them partially guilty? Because the offense for which they have been held has not been proven so far in the courts. Now let me tell this to you. 75% of India's jails, or 75% of the capacity of our jails, is occupied by under trials. Okay? Now this is bad, because had our courts been fast when it comes to delivering verdicts, okay, the fate of these under trials would have been decided. They would have not crowded these jails. 75% of prisoners in our jails, well, the crimes against them have not been proven till now. This is the problem of under trials. Clear? This is very big problem. Overcrowding and under trials. Overcrowding is because of under trials. Then staffing and infrastructure shortage, staff shortage, infrastructure shortage. Then there are cases of torture, human rights abuse, and all that, safety. And then there is judicial backlog, pendency in judiciary, plus there are allegations of corruptions also against jail officials. So these are some of the problems. Clear? Now, to solve for these problems, some reforms have been conducted. Okay, so let's talk about these reforms, okay, very quickly. So, prison reforms. Remember this, that police, law and order, and prisons is a state subject, which means that only states can make a law on prisons. Center does not have the power to make a law on prisons. Okay? Now, because it is a state subject, that is why different states have different laws with respect to prisons. Some are good laws, some are bad laws. Now, government found out that certain states are basically operating really bad laws. So what did the central government do? Central government cannot enact a prison law because, well, prisons is a state subject. Therefore, central government basically enacted Model Prison and Correctional Services Act. Now, the word model over here means that the central government, the parliament has enacted this law. States are free to choose this law or not. But this is a model law. Every state should follow it. Okay. So remember, this reform, Model Prisons and Correctional Services Act 2023, was shared with states. Some states did implement this law. Then, how the jails would be operated? There are certain set of rules. Every jail has a prison manual. So center enacted Model Prison Manual so that the rules and regulations of jails are humane, doesn't have human rights abuses, and many good things. So this is one such reform. Then, e-prison project uses technology to create digital inmate records to prevent overstaying their sentence. Then there are many people in our jails who are in jail because they can't afford a lawyer. So government has opened legal aid clinics in many of these jails. Legal aid clinics provide free lawyer services. So this is there. Plus, there are many foreign prisoners in India. Foreigners who came to India and were arrested and are in our prisons. So government enacted Repatriation of Prisons Act back in 2003. This allows foreign prisoners to serve their sentence in their home countries and vice versa. Clear? So these were some of the prison reforms. But the big problem was under trial. 75% of our prison population, well, is under trial. So what has the government done to solve for this problem? You remember we enacted Bharatiya Nagrik Suraksha Sanhita. Well, within Bharatiya Nagrik Suraksha Sanhita, government has inserted certain provisions which will help in reducing the number of these under trials. Okay, what are these provisions? Well, section 479 of Bharatiya Nagrik Suraksha Sanhita, which replaced CRPC. Well, certain under trial prisoners will be automatically released on bail. And under trial prisoners can be released on bail if they have spent up to 1/2 of their maximum prison term. So let's suppose they were accused of a crime for which the punishment was 10 years of jail. But they have already served 5 years in jail and the court has still not decided the verdict. So they can be released on bail. Clear? Release for first time offenders. There are certain under trials who committed a crime for the very first time by mistake or anything. Okay? So for them, a first time offender can be released on bond after serving up to 1/3. So normal prisoners 1/2. Well, for first time offenders 1/3. Okay? But certain prisoners, certain under trialees will not be released on bail. Who are these under trial prisoners? Who are accused of a crime for which the punishment is life imprisonment or death. They won't be released on bail. Clear? Jail superintendents are required to submit a written application to the court to release eligible under trial prisoners on bail or bond. Again, the purpose of section 479 is reduce overcrowding and ensure fair and timely justice. Make sense? So this is something that we have done within our legal system to reduce under trial population. Okay? Plus, another reform that has been in India since 1997, but now more and more states are adopting that reform, okay, is the concept of open prisons. Rajasthan is a pioneer in establishing open prisons, okay, but now more and more states are adopting this model of open prisons. Now, what are open prisons? This is a very good reform, okay. Well, these are prisons with minimal security, okay, minimal security. In this, the prisoners with good behavior can live with their families. So it is a kind of prison in which the inmates, the prisoners, live with their families and they can go out of the prison in morning, work and come back in the evening. Prisoners with good behavior can live with their families and are allowed to leave during the day to work and return at night. Okay. Open jails are available in many states, with Rajasthan having the highest number. Okay, remember I told you that prison is a state subject. So some states allow open prisons, some states do not allow open prisons. Rajasthan does. In fact, Rajasthan has the maximum number of open prisons. The first open prison in India was Sanganer in Rajasthan in 1997. Now remember this part. Open prisons, many of you might think this, that open prisons, well, it is very easy for the prisoners. Okay, why do we have open prisons? Well, open prisons were established for prisoners with very good conduct record and who were arrested for minor crimes. They are not a danger to the society. Plus, through open prisons, these prisoners still can establish a contact with society. So when they get out of prison, they have no problem in adjusting to society. So that leads to better rehabilitation. So only convicted persons with good conduct record who meet specific criteria are eligible for transfer to an open prison. As of 2022 report, there are 91 open prisons across 17 states in India. Rajasthan with maximum and the first open prison. Okay, so this is open prisons. Clear? By the way, some pros and cons about open prisons. Okay. Well, the benefits of open prison is aids in social reintegration because the person is still in touch with society. So he will have no problem in readjusting to society once he gets out of prison. Then psychological health of prisoners. Then reduces the burden on prison system, prison guards, reduces the likelihood of reoffending. Plus, the cost of operating an open prison is very less than cost of operating a full-fledged proper prison, because you spend a lot of money on the security of that full-fledged prison, right? So it reduces cost as well. But yes, there are some disadvantages as well. There is risk of escape. A person might escape. Not appropriate for all criminals, obviously. Petty minor offenses. People who are accused of these petty minor offenses should be in this. and lack of acceptance in society. Many people say that an open prison should not be established in their vicinity. They don't like to be surrounded by criminals. So this is a problem. Clear? And last prison reform that we are going to talk about, and there can be a high chance, okay, there is a high chance that a question or an MCQ might be asked from this next topic, and that is parole and furlough reforms. So what is a parole? It is a conditional release often granted for a specific reason such as death or wedding in the family and is not considered an absolute right. So prisoners are released for temporary period, for wedding in the family, death in the family, or any other compelling reason, for 5 days, 10 days, and then they come back. This is parole. Then there is furlough. Furlough is given to prisoners. It is like parole only, but parole is given for a specific reason. For furlough, you don't require a specific reason. It is a temporary release seen as a right for long-term prisoners so that they remain in touch with their family and all. But basically, you release the prisoner for some time and then they come back. Parole and furlough. Now, government wants more access to parole and furlough to prisoners. That is why Model Prison Manual, in which Ministry of Home Affairs gave guidelines to different states to reform their parole furlough system. Supreme Court has also said that there is a need for a uniform policy for parole and furlough in all states. Plus NALSA, National Legal Services Aid, okay, National Authority for Legal Service Aid. They are also creating standard operating procedures as to how parole or furlough should be granted. By the way, you understand the basic idea what is a parole or a furlough. Let's talk about the difference between the two because it is very important. Okay, parole is granted for a specific reason, granted for a variety of reasons. Furlough, part of the sentence, this is very important. So let's suppose I get parole. I'm in jail and I get parole. I go outside for 10 days. Those 10 days when I'm outside would be considered a part of my jail term only. Okay, but in case of furlough, if you spend 10 days outside, those 10 days won't be considered a part of your jail term. You will come back and resume your jail term. So this is better parole. Okay, parole can be granted multiple times. Furlough is granted rarely. Clear? That's about it. That's all you need to know. Okay, I'm not spending that much time. Just read through it. Clear? And that's about it. That's all as far as criminal justice system is concerned. Now tomorrow is your test. Take the entire day of tomorrow. Take entire Sunday to revise whatever we have covered in the past 10 days and then give the test sincerely. Please do not miss out on that. Okay? And I shall be signing off with the promise of seeing you again with another topic. Thank you, everyone.